Mr. Chairman, members of the Commission and Commission staff. I represent the Chamber of Commerce, Cape Cod Chamber of Commerce. Mrs. Northcross is here, and she may want to add to these comments. We have written an extensive statement on the draft, and I believe it was Sharon. We may have made a couple of minor changes there. But basically, I won't read the statement, but just to highlight, we commend the Commission staff on the vision and goal of the new draft, because the new draft recognizes a growth policy that I think we're pretty much in agreement with. It recognizes inevitable growth and change by proposing that we guide development towards areas that are adequately supported by infrastructure and away from areas that must be protected. And the emphasis on regional planning and regional regulations supported by this land use vision map, and the focus on economic centers, villages, and service and trade areas we like very much. And also the fact that the planning is intended to be measurable and achievable in the next 5 years, linked to these resource maps. We also are supportive of the flexible thresholds that are envisioned as the map gets delineated, and we believe that these regulations further recognize both the smart growth principles and the rural and the urban nature of Cape Cod, rather than a one-size-fits-all policy. A couple things, though, that we would ask that whether this timetable is cast in stone. I believe Sharon said that it is. But we would suggest some workshops of peer groups, particularly in the economic development section, because we believe essentially there are some assumptions made in the economic development section that we don't believe exhibit reality with market forces and with economic forces out of our control. And we think that a thorough discussion of that should take place with people that are in it on a daily basis in terms of workforce development, capital formation, small business technical assistance. The Chamber has a sister corporation which delivers not only capital but small business technical assistance with the support of the SBA and the University of Massachusetts at Dartmouth. And we believe it's a really strong program that caters to the fact that we have 9,000 businesses here, a great majority of which have under 20 employees. We have no big companies here to speak of, and we need to pay attention to the precarious nature of some of these small businesses, which we do on a daily basis. So we believe that we have strong experience in that regard, and we would hope that the Commission staff would sit with some peer groups that might take a much harder look at the economic development issue and the complexity of it as a region. The other aspect of the plan, which is a little bit perplexing to us, is the implementation part of what has taken place. Historically, if we look at the time from the inception of the Commission to now, we've gone through a tremendous population growth, tremendous growth pressures, particularly from a residential standpoint. And I think that the Business Roundtable feels the same way on this, that the five major issues that the Cape faces as a region are affordable housing, wastewater, zoning and sprawl, economic development, and transportation. And I think you could arguably say that we haven't made much progress in any of those areas in the last 10 to 12 years. The wastewater issue is a case in point that the implementation of a solution to the wastewater problem has basically arisen from the civic and political side of our society here. And this is not to denigrate personnel or people involved in the planning and regulatory part, but it's just the nature of the beast that initiative for action in solving these problems is a combination of what I call the civic and the political side. And so, generally speaking, on the public side, we acknowledge that infrastructure issues are completely within that ken and are suited to for solving from what I term the public side. Even though we as a region, we have 15 strong local governments, and it's difficult to get them to cooperate sometimes. The wastewater issue is a perfect example of the need for what I call really strong, concrete, coordinated action to make certain that we're attacking that problem from a watershed standpoint. And I guess what makes us a player in that is that we think that the initiation of a solution to this problem comes from the civic and the political side. This Cape Cod Water Protection Collaborative, which the county commissioners have supported and instituted, is a perfect example. That group is not even mentioned in this document, but that group has made significant strides towards what I just talked about. And further, they're pretty close to a piece of legislation that's about to pass the state senate, which would allow for zero-interest loans from the state revolving loan fund, which would be a significant financial benefit to the community. And it's a case in point that I'm trying to say that the civic and the political side really has a role to play in that. And somehow I think that fact should be recognized in this document. So I guess what along with other sections in here that Sharon and the staff can look at, we think that there's some objectivity needed in some of the regulatory descriptions, and we would offer support and coordination with the kind of peer group that you deem necessary to just take another look at that whole section. But as it's written now, I don't think we could support it. And so with that, unless Wendy wants to add anything, I think I've covered what our objections are, but I'll leave this written statement to Sharon, and thank you very much for your time.
Thank you very much, Mr. O'Brien. Next, Pat Butler.
Thank you, Mr. Chairman, members of the Planning Committee. I appreciate this opportunity. I have a handout if I could come up and give it to you. Thank you very much. I've left additional copies of the handout if any members of the audience want to follow along. First of all, I appreciate the opportunity to provide comments to you this evening. I know that you as a committee and the staff, Sharon and all of the staff, have worked very, very hard on the preparation of this draft document, and I think the hard work shows. And I want to compliment you for that, and thank you for that. I am appearing before you as a resident of Centerville. I am not appearing before you as an attorney representing any client. I'm not being paid for this appearance, nor am I looking out for any particular client's interest. But having represented applicants in over 100 DRI applications over 17 or 18 years, we think that this is an opportunity for us to provide you with some hopefully constructive criticism and input, as well as suggested changes in certain areas. Let me say that our comments are not intended to be critical of staff or of you or of the document just for the sense of being critical. However, I think when you get to the point where you're vetting a document like this, that's what you're asking us to do when you ask the public to turn out, is to take a hard, critical look, and hopefully you'll find our comments helpful in your process. Let me point out a couple of things where I think there's been an excellent job done in this document. First, the division of planning and the regulatory into two separate parts of the document, and the emphasis in the beginning on planning before you get to the regulatory, I think is a very positive development. I think that many times when we've represented applicants before you with applications for DRIs or exemptions, it's been very difficult sometimes for the applicant and staff and the subcommittee to delineate the distinction between the planning component and the regulatory component. Let me also say that I think some of the things that you've seen on the screen tonight and that I've seen in the document are very good improvements and address, actually, as I sat here tonight and watched some of the things that Sharon put up, they actually address issues we've had in various DRIs on various matters. A couple of examples: the ability to have flexibility in how you deal with open space. I think the wetland resource section has been improved. The ability to pay traffic mitigation without having to go through a study. How many times have we run into that issue through the years? The credit for hazardous materials removal. The ability to get credit for LEED certification. All of those are very positive developments, and we applaud them, and we think you're to be complimented. What I'd like to do tonight, and I'll try to be brief, is to go through two different areas. One is process and timing of this review process, and the second is the substantive comments, and I'll walk you through the handout to deal with that. In terms of timing, Mr. O'Brien referenced this as well. We did a little analysis today just to get our arms around the timing of your review. And I'm just going to throw this out for your discussion with your in-house counsel or whoever you deem appropriate. Our analysis is that Section 8, A through G, which talks about the 60-day period and the 45-day period and all the things that were on here, applies to the first draft of the regional policy plan after enactment of the Cape Cod Commission Act. The only section that applies to amendments directly is Section 8H. And I believe that a reading of that, a careful reading of that, would tell you that you are, until such time as you file this document as an ordinance with the Assembly of Delegates, you are under no time constraints. And so, as I get into my presentation and I talk about some of the things we'd like to be involved in moving forward, I'd like you to revisit through the appropriate mechanism whether or not those time constraints apply or not. I do think that there is an opportunity, even within the time constraints, to involve the public in a very fundamentally appropriate fashion, and we're prepared to volunteer to help in that effort. Having said that, let me turn to my handout. The first part of the handout references what I think is a very important and fundamental aspect of this review, and that is, I think that there's so much going on of a very positive fashion that you need to use what I call the three-legged stool. And the three-legged stool is this process, which is the RPP update. But at the same time, it ties into the thresholds and the mapping process. And the mapping is critical, I think, and I'll be talking about that in a minute. Because many, many places, as you read through this plan, it references the mapping. And until the mapping is done, I can't really comment. One of the things I want to talk about is our ability and your ability to run what I call test cases. Take things out for a test run in terms of some projects that have gone through and see how it compares with how that project as a DRI or a DRI exemption went through the process and how it would now have to go through the process. Or looking into the future, the types of projects that may come to you and how that would work. And I'm going to talk about that just a little bit more in a minute. And then the third leg of the stool is the work that Sharon and others have been doing, and we as stakeholders have been involved with, which is the limited DRIs and the change to Section 4B, where you're going to be able to possibly take a DRI and only look at certain pieces of the impact puzzle. I think those three elements all together have to kind of come together at the same time because they're all interrelated. And I don't know exactly how to do that, but I want to throw that out for discussion for your consideration as we move forward. Some of the key generic issues under the RPP that we've looked at thus far. As you may know, we spoke previously about the benefits of Section 4B of your regulations, which is the ability to utilize a redevelopment project and avoid full review or have limited DRI review if that project creates less detrimental impacts than what's out there now. And it's intended to incentivize redevelopment. I would point out that I think, having read this document, that there is a step backwards from the incentivization of redevelopment. I think there should be more incentivization of redevelopment, and I think we can work with you on that. One of the things that came out of the 21st Century Task Force was the need for better predictability. And I think there's some question as to whether we've gone that direction or whether there are areas where, because of the subjective nature, some of the definitional issues, whether predictability has become less in this document. The utilization of objective standards and criteria. I'm going to give you a few examples in a minute of where I think we've actually created subjective determinations in a way that will make it difficult for someone who comes to my office or who asks for counseling from me as to whether or not they should apply for a DRI. How are they going to get through the process? How long is it going to take? How much is it going to cost? And I'll point out a few of those. I had to throw my silos in here because I talk about it every time we talk about the RPP, but that's the fact that we have water resources in a silo and traffic in a silo and open space in a silo and affordable housing in a silo. And is there a way to interrelate those? And maybe if we have 10 acres of open space, maybe using one or two of those for affordable and getting some credits for that. That doesn't happen in this document very much, and we'd like to talk about that. Probably the most important thing that I picked up reading this document was the change from ODRPs to best development practices. And I have my RPP, and I'm going to be referring to some page numbers, so if I'm off, I apologize. But on page 87 of my RPP, there's language that says, basically, if we had a project today that was a DRI and I did not meet an ODRP, it would not be counted against me. It could not be counted as a detriment. They all are counted, if we meet them, as positives. The ODRPs have been changed to best development practices, and now it says, a lack of compliance or consistency with a best development practice may be considered by the Commission to be a project detriment. The performance of a DRI relative to these best practices will be part of the Commission's holistic determination of the project's benefits and detriments. As an applicant's attorney and as a practitioner and as someone who deals with regulations fairly regularly, that is troublesome language to me. For instance, up above it says best development practices may be considered as a project benefit. It doesn't say shall be considered. And the way I've described this is that in essence, the best development practices are becoming ad hoc or de facto minimum performance standards. Because I think if somebody was asking me, can we get this DRI project approved, I'd have to go through each and every one of those and say, okay, how is the subcommittee going to weigh this? And if it's a detriment, how am I going to address it? And I think if you make that decision, and if the Assembly of Delegates makes that legislative decision, that that's how we're going to treat these, that's fine. But let's know what we're doing going in, that's going to occur, and let's try to figure out from a subjective versus objective criteria how we address that. The concept of using those as credits in and out of certain mapped areas makes a lot of sense. And I think that's a good development. The problem is I don't know the maps yet. I'm from Barnstable. I couldn't tell anybody anything of what this might mean in the town of Barnstable. And lastly, I have down here the need for definitions. If you go to page 93 of the RPP, I just want to read you what it says about the Regional Land Use Vision Map. It says the Regional Land Use Vision Map guides application of new flexible thresholds, cash mitigation options, minimum performance standards, and development review policies. And if you go over to LU 1.1 on page 95, it says development and redevelopment shall be consistent with both the category of desired land use where the project is located as well as the characteristics as identified on the Regional Land Use Vision Map. So if I open up the RPP, if I'm a new applicant, and I go to the very first minimum performance standard, I have to have those maps. And I can't understand what it means if I don't have those maps. Let me just run through one last point before I run through some examples. My last item under the generic issues is the need to test run actual projects. And I think, I'll tell you what we're working on. I don't have it ready to give to you tonight, but I think it will be helpful to you as we move forward. And it's a spreadsheet where we've taken each and every one of the NPSs and the best development practices and taken an actual project and run it through and said, well, what happened when it came through the first time and what's going to happen now? And the projects we've done here, for examples, are IFWA, International Fund for Animal Welfare, Cape Cod Hospital Shaw's Orleans project, redevelopment project, and Lookout Ridge, which is a residential subdivision. And at least initially, we're seeing things that tell us that perhaps what's happening in this isn't what you intend. And we'd like to share that with you more specifically. And we're going to be talking, as Mr. O'Brien did, about the benefit of perhaps having some workshops for those of us who practice in this, who can come in and volunteer to sit down with you or your staff. And I know you put a lot of time in, but I think going through that process would be a great benefit. Let me just give you a few examples of some of these generic things in terms of actual application. If you go to section Minimum Performance Standard LU 1.2, it says development and redevelopment shall be clustered, and it shall have incorporate features such as multi-story buildings, a mix of uses, minimal setbacks from the street. That's an example. LU 1.2 is a minimum performance standard that I would suggest as an example you need to run to see how it works. In terms, and definitional issues. What is a mix of uses? And how do we define that? And how does that apply? And I'll tell you why I'm suggesting you need to do this, because otherwise you're going to see every applicant coming at you with a flexibility standard. And we know how difficult that is to apply, and we know it's our burden, but it's going to mean we're going to have to do it. If you look at ED 1.1. Oh, I'm sorry, I missed one. LU 1.3. LU 1.3, I think, is just an example of how you need to look more carefully at how we define things. It says, GRIs should be located in economic centers and industrial and service trade areas, as identified on the land use vision map, or villages where appropriate. The first question I have in reading that is, how do we define what's appropriate? The second question I have is, what about a residential subdivision? The subdivision of a 30 acres or more, or the creation of 29 units of housing or more, is a DRI. And just looking at the map, I would assume there are areas where you would have that outside of these areas, so I couldn't meet that standard. If you go to ED 1.3, that says industrial and service trade areas should be reserved for light industry, and then ED 1.4 is a best development practice. Development should incorporate a mix of uses. The question I ask is, what is meant by that? Do you mean residential and commercial? If you go to the next part, it says, in economic centers and villages, the mix should include both commercial and residential. And again, if we test drive that, if we talk about Fontaine Medical Center, if we talk about the YMCA, if we start looking at the actual application of that, we have to see what that does. ED 1.6, redevelopment. It says development should reuse and renovate existing structures or locate on previously disturbed or developed sites. That's a best development practice, and perhaps that's a benefit, perhaps it's a detriment. The question is, does it incentivize redevelopment? And that's one of the key things. Very briefly, I'm just going to hit a couple more. ED 3.1. ED 3.1 is a minimum performance standard, and it's an economic impact information requirement. And it says that you can waive this requirement if I can show the project meets 3 out of the 5 best development practices. Well, that turns the best development practices into a minimum performance standard for me to be able to get out of this, I suppose, in a backward sort of a way. Other examples I wrote down here were Cape Cod Hospital, some of the medical office buildings, RHCI, and how that would be impacted by that particular need and what the benefit of that would be. ED 3.7. which is on page 101 of mine, says development should encourage and not undermine, I don't know how I define undermine, locally owned businesses. And I stop there because I don't find a definition of locally owned business. And we get into the question, and I don't have a, please bear in mind that if the legislature of this county and the town council of the town of Barnstable, where I live, decides they want to do something to protect locally owned businesses, that is an appropriate legislative decision. It's an appropriate use of their power. But I think we need to, again, think through the consequences and how you, sitting on subcommittees, are going to interpret that and utilize that, and how we as applicants are going to have to meet that burden. Switching away from economics, if you go to TRO2, which is on page 128, this is an example of how I think by working in a workshop setting just on the traffic in a relatively short period of time, we can make some suggestions that will make this document work better. If you look at TRO.1, it says, for the purposes of DRI review, trip generation data from the ITE shall be used as the preferred source. A project-specific trip generation study may be used at the discretion of the Cape Cod Commission. That's an example of where we think that should be something that the applicant, at the applicant's own discretion, may use. Because we've always had, I believe, actual counts, if they're done properly, be valid data. If you go to TRO.2, it says, for analysis and mitigation purposes, at the discretion of the Commission, past uses of the site may be utilized based on estimated daily trip generation. And then it goes on to say for the immediate prior use and not more than 3 consecutive years. The question is, when does that 3-year period run? You probably want to put the words at the time of filing or upon completion of the application. And the question is, should it be 3 or 5? These are examples of things that we don't want to tie up everybody tonight, but we want to have an opportunity to sit down and talk about. Let me sum up if I could. And again, we appreciate the opportunity to comment. This document is a positive step forward. We think it is in many ways in conformance with what the task force told you and the Assembly of Delegates to do. And I should note that the Cape Cod County Commissioners have also given direction in this same vein, and we think it's appropriate. We would suggest that there's a need for a couple of things. To the extent that it would be helpful to you and to the Assembly of Delegates and to everybody else you hear giving public comment tonight, to extend the time period to allow that to occur, we'd ask you to look at that issue. And we'd be happy to work with your legal staff to provide input. We think it would be helpful for you to have public workshops, either broken down into one specific issue area or several specific issue areas, and to reach out and allow us to help you reach out to bring people forward. I always tell the story that the last regional policy plan, 2002, at the end of the day before the Assembly of Delegates' final public hearing, there were 2 people there, myself and Roland DuPont. And I think we both turned to each other and said, where's everybody else? I think you're going to see a lot more input this time around, and you should cherish that input and use it and have us help you. And lastly, to the extent that there is a desire to have the private sector, such as referenced by Mr. O'Brien and myself, be involved, I think your staff and you should feel free to call upon us. We'd be very willing to assist. And I think that workshop could lead to an expeditious redrafting of the document that would be an appropriate document to then send on to the Assembly of Delegates. Thank you very much.
Thank you, Mr. Butler.
Good evening, and thank you for giving the general public, out of 200 and some thousand people, this opportunity. Let me begin by, my name is Peter Kenny, and I live in the town of Yarmouth, and I'm not affiliated with any group other than I watch a lot of things that happen. I'd like to start with my ending comment in my notes. We really do need more time. Respectfully, and I understand there's a lot of work involved, and I understand it means more committee meetings, but you volunteered. 60 days plus a rewrite with no public comment and then to the Assembly is just not enough time. And what you will have is warfare, because the document is full of, well, I began to hallucinate as I was reading it, and I was sure that I saw in very faint ink stamped on every page, trust me. I don't. For example, the literal word McMansion appears in this document. I can't find it in a dictionary. I've built quite a few, but I don't know what it is. And this document doesn't tell me what it is. It doesn't tell me that it's 6,000 feet. It doesn't tell me that per acre the lot coverage shall be less than 15% or it will be a McMansion. It doesn't tell me that more than one bedroom per family member makes it a McMansion. It doesn't tell me that a boat dock or more than a two-car garage. It tells me nothing. It tells me that this document intends, accidentally or not, to give the commission that trust me authority. Well, you know, somebody famous once had a house, and in his view shed was this house, so you can't change it. You can't tear it down. Or somebody we think was notable once had this open field as part of his view, and we really think it should remain an open field. And oh, by the way, it looks to us like you're building a McMansion. Now, come on. As a regulatory board, how can the Cape Cod Commission actually intend to enforce a word that doesn't exist in the language? It's not yet a term of art, and for which there's no definition, either quantitative or qualitative. That simply is inappropriate. That has to come out. I mean, that's just, and I have to tell you, for the largest regional planning agency in New England, one of the largest in the country, with one staff member for roughly every 10 square miles of our area, including both the National Seashore and Otis, it's amazing that that's in there. Not in one place, but in two or three. What this tells me is that the door is being opened wide for discretionary referrals of single-family residential projects. All you have to do is say, it's a McMansion. It's changing the community character. It's altering some historic view shed. Remember the building that the conservatory had so much trouble with in Falmouth? One of the Lilly houses that had been given to them? And there was war over saving that building. You know what that building was? It was an early 19th century McMansion. But in that instance, oh no, we have to save it. You can't take it down. You can't put up a building that's more energy efficient, that's more practical to your uses, that will be equally, if not more attractive. Nope, can't do that. I've driven by that every day going to and from work, and I love seeing it, and I want to continue seeing it. We cannot be that arbitrary. We cannot be that mysterious. We cannot be that subjective. And yet we are. 2.5 years worth, and we still are. I do find it interesting that the Cape Cod Commission, according to this, is going to perform an analysis of the cost of doing business on the Cape. Do you have an MBA on staff? Do you have a small, medium, or large business person on staff? Do you have an accountant on staff? Do you have a business consultant, an expert on staff? Do you have a production engineer on staff? Let the businesses figure out if they can bear the cost of doing business. And by the way, what do you suppose one of the largest individual costs, capital costs, is for a business that wants to build or perform a major renovation or expansion? It's right here. Analyze those costs, and we will make progress. But the notion that the Cape Cod Commission is going to conduct a full analysis of the overhead costs and the other cost burdens of doing business on the Cape is just insupportable. And again, to me, it opens the question of subjectivity. Well, that cost really isn't important. Well, of course, everybody has to do that, so we won't count that. I'm accustomed to building houses that cost millions of dollars. I can tell you about overheads. I'm not sure anyone in the Commission could do that. It's not a criticism, it's just a fact. The Commission, by its very nature, is an accumulation, an aggregation of planners. Not business people, not accountants, not management experts, planners. So unless you have an intention of letting out an RFP to bring in an Anderson Associates or an Arthur D. Little, whatever you come up with is not going to be satisfactory to the business community. And I think I'm not alone in this, kind of expected some changes in DRI thresholds. Not a proposal that if we get to a satisfactory mapping, and if we get that through the subcommittee and the commission and the Assembly of Delegates, then towns can apply for. And here again, there's nothing definite. This doesn't tell me anything about what any of us in this room or anywhere in the Cape should expect for DRI thresholds. Next week, next month, next year. It tells me that maybe there's a possibility, if and only if. Those two letters, IF, what an enormous impact that word has. If what? If the commission likes the proposed development? Don't we need regulation? Shouldn't they be available for everyone to read and understand before committing to an enormously expensive, talking about business cost, design process? Remember now, this is the body that held up a development for, that required 8.5 years to review one project at a cost to the applicant of over $4 million. You want to study the cost of doing business on the Cape? Start with that one. I have questions. There's so many questions about individual points, so I'll just hit some of the highlights, just things that keep me awake. Where in the Cape Cod Commission Act is the Commission or the Assembly of Delegates given the authority to specify by name a contractor whose services will be used by an applicant? Anybody? The Cape Light Compact is so named. So if I were a DRI applicant and I'm going to have Stone & Webster do our energy audit, I would still have to pay the Cape Light Compact to do it? Registered professional engineers, world-class engineers, Charles T. Main, pick an engineering firm, they wouldn't do? That has to come out of this. There's a big difference between requiring that energy audit of a proposed project and saying, oh, by the way, these are the people who will do it. You know, a building inspector can't argue with a certified engineer, registered professional engineer. Cape Cod Commission apparently can. I have some problems with mandatory affordable housing in this sense. It seems to me patently unfair to say to the new kid on the block, we're going to make you pay for things that those who've gone before you, whose projects predated or eluded Cape Cod Commission action, didn't have to pay for. So if you were going to do, here we go again with this cost of business, cost of doing business. If you're going to do the cost of business analysis, understand that you have to do it at least in 2 tiers. Those who've gone before and those who are starting from this point on. Because from this point on, the costs they'll be enormously superior to the previous costs. And that's just not fair. Now, we can argue all night about whether the towns have dropped the ball and shirked their responsibility to take care of transportation, crumbling infrastructure. We can talk about the state. We can talk about the federal government. But the fact is, you're placing the burden of addressing all these issues on the new applicant. How many of them do you think you're going to encourage to come here? Or for that matter, to stay here? If the choice is stay and expand, or, well, let's see one example from a company in Harwich, go to Pennsylvania and employ 45 people down there. Plug that into your analysis of doing business costs and see what it looks like. It's gruesome. You know, every well has a bottom. Speaking of costs, we're actually involved in serious discussion here of a proposed regional policy plan update, which will become a county ordinance. But in this, there is no way to quantify what you propose to charge for mitigation. I don't think Pat Butler could tell you right now what a theoretical project would cost. One fellow told me he sort of doodled a project and he came up to $80 a square foot. Well, when you can construct pretty good new commercial space for $100 a foot, and if you add up all these little pieces of mitigation, you add $80, forget doing a study of the cost of doing business on the Cape. There won't be any new business on the Cape. Now, you have to get to that level of detail in this document, because if you don't, you will, and you do, and historically always have gotten to this level of detail in an actual DRI review. And who pays for that? The applicant. He shovels money out to his engineers and his architects and his attorneys and other business professionals because the rules aren't clear. You can't hang a number on them, and that is not the way it's supposed to be. It's fine to build a 12,000 square foot house on 67 acres on Nantucket, and the guy says, I don't care what it costs, just keep building, fellas. Most of the people who come before you are not approaching life that way. 10% on-site energy generation. What am I missing? Who's going to determine how that will happen? Has the Commission done an analysis of the various types of buildings that will come before them to determine if that's practical? Can the Commission assure us that those technologies are available and permittable in the towns? Well, let's just pick a number, 10%. Folks at Cape Light Compact said that's a good number. Not necessarily. Not if half your building is a refrigerator or a freezer. Want to talk about the cost of doing business on the Cape? Do you know what the cost is in today's technology, of advanced technology for on-site energy generation? It's enormous. Well, yeah, but the payback is 10 years. Yeah, but will he be around in 10 years? Regional Policy Plan also calls for the use of local professional services. What? I'm an applicant. You're going to tell me that I have to have an attorney who's based on the Cape, an accountant who's based on the Cape, an architect who's based on the Cape, an engineer who's based on the Cape? Well, you know what I'd say? Middleborough's not that far away. Nor is Plimpton, nor is Plymouth. I think the Cape Cod Commission is probably, up and down the eastern seaboard, one of the best economic development agencies I've ever seen. Unfortunately, it's developing the economies of other towns off Cape by repelling precisely the kind of development you say you'd like to see. It's all well and good to say that the document's been rearranged. Well, you move the deck chairs in the Titanic, you still have a sinking ship. The idea of separating it into a regulatory and a planning document so that at least half of it is available to the ken of ordinary people is a good idea. Should have been done a long time ago. But if, when you do that, you have the same baggage that got us to the 21st Century Task Force, that gives rise to the criticisms that continue, what have you done? And I don't see, quite frankly, how by August 4th you're going to be able to have enough review of this. Remember, it's summertime on the Cape. A lot of people are busy because this is their season. This is when they pay all those costs you'll learn about in your study. And I don't think having a 30-day period for the Commission to adjust this document or rewrite it with no public comment is enough. I think Pat's suggestion is excellent, and you should understand how valuable it is for a man of his expertise and experience with this particular body to volunteer to help in that process. But there's a lot of work to be done here. Good start, we'll see. A good ending is usually indicative of a good start. We're not headed to a happy ending here. There's too much in here that's vague, that's subjective. There is more regulatory clout coming our way, not less. There is very little, if any, incentivization for any kind of development that I can see. And I'll leave you with this, I guess, ironic quote from the former executive director of the Cape Cod Commission, who, we have 3 of our selectmen here, who actually said in Yarmouth Town Hall when she appeared before the Board of Selectmen, talking about growth incentive zone, she said, you want to get the Cape Cod Commission out of your hair, and I agree, it's probably a good idea. The GIZ is the way to go. Well, let's forget the GIZ is the way to go. She agreed it was a good idea to get the Cape Cod Commission out of our hair. Well, if the Cape Cod Commission doesn't want to lead and doesn't want to follow, get out of the way. There are people in this room who know how to develop good projects, and they do. on their own dime. They don't need $200,000, $300,000, $400,000 and more in additional costs just to go through a vague, bureaucratic, and in my opinion, often arbitrary review process. They could do better with that money if they just built 2 or 3 houses for workforce. So can we please keep this process open? I would encourage you to read this again and ask yourself, if I were appearing before the Cape Cod Commission and my livelihood depended on a successful outcome, does this document help me? That's how you analyze the cost of doing business. Thank you.